Hello and welcome to Bar 10 Test Prep, where we help you prepare for the bar exam 10 questions at a time. Don't forget to like, subscribe, and click the notification bell so you can be updated every time we upload new content, which is usually at the very least at 8 a.m. Eastern Standard Time every day of the week. Question number 1. Elda, the aged mother of Alice and Barry, both adults, wished to employ a live-in companion so that she might continue to live in her own home. Elda, however, had only enough income to pay one half of the companion's $2,000 monthly salary. Learning of her mother's plight, Alice and Barry agreed with each other in a signed writing that on the last day of January and each succeeding month during their mother's lifetime, each would give Elda $500. Elda then hired the companion. Alice and Barry made the agreed payments in January, February, and March. In April, however, Barry refused to make any payment and notified Alice and Elda that he would make no further payments. Will Elda succeed in an action for $500 brought against Barry after April 30th? A. Yes, because by making his first three payments, Barry confirmed his intent to contract. B. Yes, because Elda is an intended beneficiary of a contract between Alice and Barry. C. No, because a parent cannot sue her child for breach of a promise for support. Or D. No, because Alice and Barry intended their payments to Elda to be gifts. Take 10 seconds, choose the best answer. If you chose option B, yes, because Elda is an intended beneficiary of a contract between Alice and Barry, then you'd be correct. Third-party beneficiaries exist when two parties make a contract with the shared intent to benefit a third person. For a third-party beneficiary to have any contract rights, the third-party beneficiary must have known of and relied upon the contract. Contracts cannot be canceled or modified without the consent of the third party if the third party had knowledge of and relied upon that contract. A third-party beneficiary may sue the promisor on the contract. In this case, Elda is the intended third-party beneficiary under the Alice and Barry contract. Elda knew that under the agreement between Alice and Barry, she would receive $500 from each of them on the last day of each month during Elda's lifetime. Elda relied on this agreement by hiring a live-in companion for which Elda could only afford half of the live-in companion's salary without Alice and Barry's monthly payments to Elda. When Barry refused to make those payments in April, he breached his contract. As such, Elda will succeed in an action for $500 against Barry as the intended beneficiary of the contract between Alice and Barry. Let's look at the other options and see if we can have an analysis as to why they would be incorrect. Let's start with option D. No, because Alice and Barry intended their payments to Elda to be gifts. In fact, the payments were in fact not made to Elda, so factually D is incorrect. The payments were made directly to the companion. C. No, because a parent cannot sue her child for breach of a promise for support. C is extremely conclusory and broad. It in essence states there is no situation under which a child could be sued. That being said, that is virtually immediately incorrect, because I'm certain that each of you could think of at least one scenario under which a child could be sued by their parent. A. Yes, because by making his first three payments, Barry confirmed his intent to contract. The issue with A is that ultimately the question is, was there a contract, and is this third-party person, i.e. Elda, do they have standing to bring suit? Here, A ignores the majority of the issues presented and in fact discusses a very different point. It ultimately says yes, which is the correct answer, that there is a claim, but makes the explanation or the rationale one that's a bit different, because by making his first three payments, Barry confirmed his intent to contract. There is no necessary confirmation to intend to contract. And if there's no standing to bring a claim, the fact that he made those three payments would be irrelevant as to whether Elda in fact has the standing or the ability to bring a claim to begin with. So as a result, the best answer here is B. Question number 2. Roberts, a professional motorcycle rider, put on a performance in a privately owned stadium during which he leaped his motorcycle over 21 automobiles. Spectators were charged $5 each to view the jump, and were prohibited from using cameras. However, the local television station filmed the whole event from within the stadium without the knowledge or consent of Roberts and showed the film in its entirety on the evening newscast that day. Roberts thereafter brought suit to recover damages from the station for the admittedly unauthorized filming and broadcast of the act. The television station raised only constitutional defenses. The court should A. hold against Roberts because the First and 14th Amendments authorize press coverage of newsworthy entertainment events. B. Hold against Roberts because under the First and 14th Amendments, news broadcasts are absolutely privileged. C. Find the station liable because its action deprives Roberts of his property without due process. Or D. Find the station liable because the First and 14th Amendments do not deprive an entertainer of the commercial value of his or her performance. Take 10 seconds and choose the best answer now. If you chose option D, you'd be correct. Find the station liable because the First and 14th Amendments do not deprive an entertainer of the commercial value of his or her performances. Generally, the Supreme Court has held that the First and 14th Amendments do not privilege the press to broadcast a performer's act in its entirety without permission from that performer. In this case, the local television station films Roberts' entire motorcycle performance from within the privately owned stadium without the knowledge or consent of Roberts. The station then showed the film in its entirety on the evening newscast. While the station can report on Roberts' performances as news, the station is prohibited from showing the entire performance without Roberts' permission. Otherwise, people may not pay Roberts $5 to see the performance live. Thus, the court should find the station liable because the First and 14th Amendments do not deprive an entertainer of the commercial value of his or her performances. Let's look at the other options, as well as a basic rationale. Theoretically, then every fight or every event that's on pay-per-view would be a newsworthy event, and as such, arguably, they should be broadcast without any cost or without any expense on the part of the news. That is clearly incorrect, and that is clearly not the way our society works financially with regards to these events. So obviously, we are aware of the fact that the performer is protected financially. Let's look at option A. Hold against Roberts because the First and 14th Amendments authorize press coverage of newsworthy entertainment events. We've already run the analysis, and that is simply inaccurate. First and 14th Amendments do guarantee privileges. However, they are not privileges that extend to the entirety of a performance. As such, the news is open to report on the event, as we previously discussed, but not in broadcasting the entirety of the event. B. Hold against Roberts because under the First and 14th Amendment, news broadcasts are absolutely privileged. Same analysis, same conclusion. A and B should be excluded as possible answers. C. Find a station liable because its actions deprive Roberts of his property without due process. Due process is of no concern because we do not have a state actor. We have a private actor, and as such, that private actor would not necessarily have a due process obligation, especially under the Constitution, to the other individual. So as a result, A, B, and C are fully incorrect, factually incoherent, and do not match the facts presented here. So D would be the only possible viable option. Question number 3. Den is on trial for arson. In its case in chief, the prosecution offers evidence that Den had secretly obtained duplicate insurance from 2 companies on the property that burned and that Den had threatened to kill his ex-wife if she testified for the prosecution. The court should admit evidence of A. Den's obtaining duplicate insurance only, B. Den's threatening to kill his ex-wife only, C. Both Den's obtaining duplicate insurance and threatening to kill his wife, or D. Neither Den's obtaining duplicate insurance nor threatening to kill his ex-wife. Take 10 seconds and choose the best answer now. If you chose option C, you'd be correct. Both Den's obtaining duplicate insurance and threatening to kill his ex-wife. Remember, character evidence is not admissible during the case in chief unless it is a sexual assault or child molestation case, or where the court has admitted evidence of victim's character offered by the defendant. However, specific instances of the defendant's prior bad conduct are admissible to prove anything else that is relevant other than character. When the court is considering mimic evidence, the court must always balance probative value of the evidence to prove the mimic fact and unfair prejudice of the evidence to prove character. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that statement. Hearsay exemptions are admission by party opponent, vicarious party admissions, and prior statement by the witness. The husband-wife privilege for confidential marital communications applies to all communications made during the course of a valid marriage and intended to be confidential. Here, Den is on trial for arson, and the prosecution is offering Den's duplicate insurance form from two distinct companies on the property that burned as proof of Den's motive and or intent to commit this arson. This evidence of prior bad conduct is admissible to prove this mimic fact. Additionally, an admission by party opponent is not hearsay under the federal rules of evidence, so the court will allow Den's ex-wife to testify that Den had threatened to kill her if she testified for the prosecution. Because Den was not married to his ex-wife at the time the threat was made, the confidential marital communications privilege does not in fact apply. As such, the court should admit both pieces of prosecutorial evidence. Question number 4. A car driven by Dan entered land owned by and in the possession of Peter without Peter's permission. Which, if any, of the following allegations, without any additional facts, would provide a sufficient basis for a claim by Peter against Dan? 1. Dan intentionally drove his car onto Peter's land. 2. Dan negligently drove his car onto Peter's land. Or 3. Dan's car damaged Peter's land. Here are your 4 options. A, 1 only. B, 3 only. C, 1, 2, and 3. Or D, neither 1, 2, nor 3. Take 10 seconds. Choose your best answer now. If you chose A, 1 only, Dan intentionally drove his car onto Peter's land, you'd be correct. Trespass to land is the physical invasion of plaintiff's real property and occurs either when the defendant intentionally enters plaintiff's land without permission, the defendant remains on the land without the right to be there, even if the original entry was rightful, or the defendant places a tangible object on or refuses to remove from plaintiff's land without permission. For trespass, the defendant only needs to intend actual entry onto the piece of land. The wrongful quality of the entry must be present in fact, but it is not required that the defendant intend that the entry be wrongful. In this case, if Dan intentionally drove his car onto Peter's land, then Dan would be liable for trespass to the land. The facts establish Dan did not have Peter's permission to enter Peter's land, and once the intent of the element of trespass to land is met, as would be with option 1, then all of the elements for trespass to land are present. The other 2 options do not provide a sufficient basis for a claim by Peter against Dan without additional facts. Dan negligently driving his car onto Peter's land would still require damages, and Dan's car damaging Peter's land would still require either intent or negligence by Dan. Therefore, only one would provide a sufficient basis for a claim by Peter against Dan without any additional facts. Question number 5. John was fired from his job. Too proud to apply for unemployment benefits, he used his savings to feed his family. When one of his children became ill, he did not seek medical attention for the child at a state clinic because he did not want to accept what he regarded as charity. Eventually weakened by malnutrition, the child died as a result of the illness. John has committed A, murder, B, involuntary manslaughter, C, voluntary manslaughter, or D, no form of criminal homicide. Take 10 seconds and think this through. If you chose option B, involuntary manslaughter, you'd be correct. Involuntary manslaughter is an unintentional killing that results either from criminal negligence or misdemeanor murder. Criminal negligence exceeds tort negligence, but is less than reckless indifference of depraved heart murder. It is not necessary that the defendant was aware that her actions entailed a high degree of risk to human life. In this case, when John did not seek medical attention for his sick child, he was not acting as a reasonably prudent person would under similar circumstances. As a result of John's breach of duty to his child died. Since John's negligence resulted in the unintentional killing of his child, John has committed involuntary manslaughter, even if he was not aware his actions entailed a high degree of risk to his child's life. If we look at option A, murder requires the specific intent of committing the murder. Here, that's clearly not the case. The death was the unfortunate byproduct of the poor decision-making of the father. And if we look at option C, voluntary manslaughter, similarly, it requires voluntariness or a specific mens rea to commit the crime. That being said, again, the fact pattern does not show us that the father actually intended to cause the death in any way, shape, or form of his son. D, no form of criminal homicide, and that is obviously inaccurate. As we noted, involuntary manslaughter is an option, and here it fits the fact pattern. Question number 6. Congress passed a bill prohibiting the president from granting a pardon to any person who had not served at least 1/3 of the sentence imposed by the court which convicted that person. The president vetoed the bill, claiming that it was unconstitutional. Nevertheless, Congress passed it over his veto by a 2/3 vote of each house. The act of Congress is A, constitutional because it was enacted over the president's veto by a 2/3 vote of each house. B, constitutional because it is a necessary and proper means of carrying out the powers of Congress. C, unconstitutional because it interferes with the plenary power of the president to grant pardons. Or D, unconstitutional because a presidential veto based upon constitutional grounds may be overridden only with the concurrence of 3/4 of the state legislatures. Take 10 seconds. If you chose option C, unconstitutional because it interferes with the plenary power of the president to grant pardons, you'd be correct. The president has some domestic affairs powers reserved to himself. These include the appointment and removal powers, the pardon power, the commander-in-chief power, and the duty to execute the law. Here, Congress passed a bill prohibiting the president from granting a pardon in a specific circumstance. Since this bill interferes with the plenary power of the president to grant pardons, the bill is in fact, on its face, unconstitutional. Question number 7. In the course of a bank holdup, robber fired a gun at guard. Guard drew his revolver and returned the fire. One of the bullets fired by guard ricocheted, striking plaintiff. If plaintiff asserts a claim against guard based upon battery, will plaintiff prevail? A, yes, unless plaintiff was robber's accomplice. B, yes, under the doctrine of transferred intent. C, no, if guard fired reasonably in his own defense. Or D, no, if guard did not intend to shoot plaintiff. Take 10 seconds. Choose the best answer now. If you chose option C, you'd be correct. No, if the guard fired reasonably in his own defense. Battery is an intentional infliction of a harmful or offensive conduct with the victim's person. Self-defense is a defense to battery. This defense extends to accidental injuries caused to third parties, while the defendant was defending themselves. A person is entitled to use reasonable force to prevent any threatened harm or offensive contact, as well as any threatened false imprisonment. A victim may use deadly force in self-defense if the victim is not at fault. The victim is confronted with unlawful force, and the victim reasonably believes that they are facing imminent threat of death or serious bodily injury. Here, robber fired a gun at guard during a bank holdup. If guard reasonably believed he was under an imminent threat of death or serious bodily harm when robber opened fire, then guard was fully justified in exercising self-defense by returning fire. Guard's self-defense would extend to plaintiff's accidental injury when guard's bullet ricocheted and struck plaintiff. Thus, plaintiff will not prevail if guard fired reasonably in his own defense. Question number 8. Oxnard owned Goldacre, a tract of land, in fee simple, at a time when Goldacre was in the adverse possession of Amos. Eric obtained the oral permission of Oxnard to use as a road or driveway a portion of Goldacre to reach adjoining land, Twin Pines, which Eric owned in fee simple. Thereafter, during all times relevant to this problem, Eric used this road across Goldacre regularly for ingress and egress between Twin Pines and a public highway. Amos quit possession of Goldacre before acquiring title by adverse possession. Without any further communication between Oxnard and Eric, Eric continued to use the road for a total period. From the time he first began to use it, sufficient to acquire an easement by prescription. Oxnard then blocked the road and refused to permit its continued use. Eric brought suit to determine his right to continued use of the road. Eric should A. Win because his use was adverse to Amos, and once adverse, it continued adverse until some affirmative showing of a change. B. Win because Eric made no attempt to renew permission after Amos quit possession of Goldacre. C. Lose because his use was with permission. Or D. Lose because there is no evidence that he continued adverse use for the required period after Amos quit possession. Take 10 seconds. Choose your best answer now. If you chose option C, lose because his use was with permission, you'd be correct. An easement is a grant of a non-possessory interest in land that entitles a person to use the land possessed by another. An easement may be created by express grant, implication, necessity, or prescription. An easement by prescription is an easement acquired by adverse possession, i.e., use of the land that is one actual, open, notorious, adverse, and continuous for an uninterrupted statutory period. Exclusive use, however, is not required. Here, Eric meets most of the elements of an easement by prescription. He openly used the road across Goldacre regularly and continuously for the statutory period, while Eric was not exclusively using Goldacre because Amos was in adverse possession during a portion of Eric's use. Exclusive use is not required for an easement by prescription. However, Eric's use was not adverse because Eric had obtained the oral permission of Oxnard to use a portion of Goldacre. Therefore, Eric should lose because his use was in fact with permission. Question number 9. Palmco owns and operates a beachfront hotel. Under a contract with City to restore a public beach, Dredgeco placed a large and unavoidably dangerous stone-crushing machine on city land near Palmco's hotel. The machine creates a continuous and intense noise that is so disturbing to the hotel guests that they have canceled their hotel reservations in large numbers, resulting in a substantial loss to Palmco. Palmco's best chance to recover damages for its financial losses from Dredgeco is under the theory that the operation of the stone-crushing machine constitutes A. an abnormally dangerous activity, B. a private nuisance, C. negligence, or D. a trespass. Take 10 seconds and choose your best answer now. If you chose B, a private nuisance, you'd be correct. A private nuisance is an unreasonable interference with the plaintiff's use and enjoyment of their land. The interference must be substantial and unreasonable. The defendant's conduct is unreasonable if the harm to plaintiff outweighs the utility of the defendant's conduct, or the harm caused to the plaintiff is greater than the plaintiff should be required to bear without compensation. The defendant's conduct must also be negligent, abnormally dangerous, or intentional. Here, Dredgeco's stone-crushing machine is creating a continuous and intense noise near Palmco's hotel. This noise is substantially interfering with Palmco's use and enjoyment of the hotel because guests are canceling in droves. While Dredgeco may argue that the noise is not unreasonable because the utility of Dredgeco's conduct outweighs the harm to Palmco, this is still the best answer option provided. Therefore, Palmco's best chance to recover damages is under the theory that the operation of the stone-crushing machine constitutes a private nuisance. Question number 10, the final question in this grouping. A state statute divides murder into degrees. First-degree murder is defined as murder with a premeditation and deliberation, or a homicide in the commission of arson, rape, robbery, burglary, or kidnapping. Second-degree murder is all other murder at common law. In which of the following situations is defendant most likely to be guilty of first-degree murder? A. Immediately after being insulted by Robert, defendant takes a knife and stabs and kills Robert. B. Angered over having been struck by Sam, defendant buys rat poison and puts it in Sam's coffee. Sam drinks the coffee and dies as a result. C. Intending to injure Fred, defendant lies in wait, and as Fred comes by, defendant strikes him with a broom handle. As a result of the blow, Fred dies. Or D. Defendant, highly intoxicated, discovers a revolver on a table. He picks it up, points it at Alice, and pulls the trigger. The gun discharges, and Alice is killed. Take 10 seconds and choose what you think would be the best answer now. If you chose B, angered over having been struck by Sam, defendant buys rat poison and puts it in Sam's coffee. Sam drinks the coffee and dies as a result. You'd be correct. First-degree murder is defined in this question as murder with premeditation and deliberation. Premeditation means a time to reflect upon the killing. Deliberate means a cool and dispassionate manner. Murder is a specific intent crime. Voluntary intoxication can be a defense to specific intent crimes if it was not possible for the defendant to have the state of mind to form the specific intent. In this case, B shows that defendant had the time to plan out Sam's murder by poisoning Sam's coffee, and defendant carried out the poisoning with a calm intent to kill. A is eliminated because defendant did not have time to reflect on killing Robert, and defendant was not cool and dispassionate immediately after being insulted by Robert. C is eliminated because defendant only intended to injure Fred with the broom handle. D is eliminated because defendant's intoxication may have prevented him from forming the specific intent for Alice's murder. Accordingly, the situation in which defendant is most likely to be guilty of first-degree murder is option B. As always, thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we upload content every day at 8 a.m. Eastern Standard Time. Don't forget to like, subscribe, and ring the notification bell so you can be updated every time we upload new content.